electronic and digital record in comparison to the other documents. This is subject to certain conditions under Section 63 BSA. And when I tried to comprehend this, I thought next that probably the framers are trying to create that this step ahead needs to be slightly more comprehensively dealt with, so that all such electronic record needs to be in proper order, in appropriate form and structure to be considered on its merit. And therefore, if you see the blue highlights, these are the new additions where they have made semiconductor memory, any communication device or otherwise is stored, recorded or copied in any electronic form, communication device, any electronic means. Now therefore, the existing section, the earlier section had the usage of computer, but the fact of the matter that they are going into this dynamic electronic processing of information, transmission of information, storage of information, all that has been very clearly spelled out. I'm sure as it rolls out, these factors would be very relevant, because the schedule now prescribes exact formats under Part A and Part B, where both the producer of the evidence digital record as well as an expert in question will have to provide under the seal of authority that this has been done in these fashions. It also talks about how this electronic or digital record was produced, how it was appropriately recorded, what was the hash value, which specific algorithm was used to create that hash value, and therefore any person owning, maintaining or managing or operating such a digital device will have to submit before the court of law that this is the integrity of the electronic data which is being produced for better adjudication. It also talks about digital referencing. Section 32 talks about, we had the provision of obviously reference to the textbooks and the publications in physical form. Now any such knowledge which is available on digital platforms can be referenced by the court of law, and therefore these can be additional resources on which the trial judges can rely upon. In the secondary evidence, the oral admissions, written admissions, and evidence of a person skilled in examination of numerary documents have been added. Therefore, there is I would say, empowerment in that sense, that probably in certain cases, these provisions would help us in the prosecution, and especially when there are large volume of data which has to be understood by the court of law in numerary documents, the evidence of a person is skilled can be relevant for us. The relevancy of fact is a very important part of the Indian Evidence Act and now Adhiniyam, and to the best of my understanding, I use the first phrase that it tried to give a comprehensive consideration of a fact, not an issue. Sometimes there could be a fact which may not be prima facie very relevant, but if it's found connected with a fact and issue, it can be deemed relevant in the subject case. So therefore, there is a qualitative change. At the same time, as Sir had mentioned in his introductory speech about the opinion of experts in any other field, that is to be seen as we go along practicing this part of the law, how these expert opinions does justice to a fair trial. And it is a step forward as far as the modern outlook of this Adhiniyam is, that the judicial notice of international treaty and agreements or conventions, the large number of, India is a signatory to a large number of UN conventions, which are in principle in tandem with our constitutional principles, all those can be taken judicial notice of. Sir had also mentioned in his introductory speech about the confession by coercion, Now, there were other elements like inducement, threat, promise earlier existing in the previous Indian Evidence Act. This is the new edition of coercion. Now, coercion is definitely, by the very fact that it has been incorporated, I'm sure there was a need felt by the practitioners of law and the criminal justice system that probably this should have been considered in a formal sense, which could have been otherwise covered under the existing threat possibly. But confession becomes relevant once the impression of the inducement has been fully removed. Confessions made under a promise of secrecy after deception when drunk, this is an existing provision of the Indian Evidence Act, which continues to be there, subject to this, that such confessions will not make it irrelevant. There was also a discussion right at the start about the joint trials. A trial of more persons, more than one held in the absence of an absconding accused. And in the fourth session, we had discussed about how the attorney, additional solicitor, I believe, she was mentioning, she was mentioning about the fact that how trials have been repeatedly done because one of the accused was absconding from the case. So this, the absence will not create impediments to the joint trial, and this can be very much considered by the court of law. The another issue which was mentioned about the fact that conviction will not be considered illegal if it proceeds upon the corroborated testimony of an accomplice. This is tuned to the provision that an accomplice is unworthy of credit unless he is corroborated in material particulars. Sir was mentioning about this, and I'm sure the enlightened mind would be better in a position to establish to resolve this contradiction, as you had mentioned, sir. And there is only one prohibition in this about that the no court shall require any communication between the ministers and the President of India with regard to production of a document by a witness. That's exactly the presentation that I wanted to make as far as the basic features of this adhiniyam was concerned. As we all know, Indian Evidence Act is actually an adjective law which helps both the substantive and the procedural law for better operations into the system. I'm sure these new changes will be quite a challenge in its implementation as far as all the particular arms acting in synergy is concerned. So therefore, as my host Shri Mahesh Saab had talked about the pains, actually the law itself per se is not painful. Actually, we need to take pains to ensure that the spirit in which it has been provided has to be applied both in terms of capability and intended use to ensure that a fair trial takes place. Thanks.
Thank you very much. I think a very elaborate presentation, and that the society is dynamic, law has to be dynamic, and the technology has overtaken everything, and therefore the technology must be reflected. And therefore, you can see the gains of COVID-19 has been nothing but the virtual, we can now, I appeared before the court just before I came to this place because it could happen virtually. So I asked them to, can I come 5 minutes late? So that's possible. That's why now the witnesses who are formal witnesses or expert evidence or doctors, they need not to come all the way to the courts. Their evidence can be recorded virtually. And therefore, another aspect that I think I need some of enlightenment from the speakers is we have extended the scope of the secondary evidence by including two important aspects, oral admissions and written admissions. But if you look at the very definition of proof of contents of document, the contents of the document may be proved either by primary or by secondary evidence. Now, why you need secondary evidence is because you want to prove a document. I do not know, I cannot conceive myself, because this is something which is new to me. How can oral admission amount to a secondary evidence? Similarly, how can written admission amount to an secondary evidence? I think oral evidence, yes. But can it gain the status of a secondary evidence? I think that's a matter I would like to be enlightened by other speakers who are speaking on the subject. I think there are many things, we need, I think courts will have to, but I think before they reach the Supreme Court, this act will also become old act. Need for a new act will set in. But then I think these are the issues that are going to come up at the magistrates court, at the sessions court, at the high court before they reach the Supreme Court. But I think the discussions like this, had they taken place before the act was enacted, I think it would have been better. But we have no choice except to deliberate after the act has come in, so we can deliberate upon it and have the expert opinion of our speakers today. Now, I think I can now immediately go to young mind, Mr. Apar Gupta, who is an advocate at Delhi High Court. I think his views on various aspects and the issues that have been raised during the course of the discussion here, I think, will be very welcome.
Thank you so much for inviting me here, and I'm grateful to the attention, the time of all the probationers, especially given how I practice as a lawyer myself and have occasion sometimes to appear before many of your much more senior colleagues. And here I think there is a great potential to overcome challenges because young people who are joining the judiciary at present have a mindset towards disposal and result and serving justice towards each litigant. With that keeping in mind, I'd like to focus on the title of today's 3 sessions. They have titled as Challenges to the Implementation of the New Criminal Laws. And here, firstly, the challenges we must recognize are not only due to the new criminal laws. That's also a structural challenge of pendency, the number of judges who are there and the backlogs which are there already pre-existing in our court system. These are not new challenges which are being created only due to the language in these laws. There were sufficient challenges as they were in the Indian Evidence Act, while there was some level of clarity there. There will be some additional ones. I concede that. The second is that especially the BSA should not be viewed only as a criminal law. I think Kabir may speak to some bits of that. We had a discussion earlier. So it should be also viewed in the broader perspective of it being applicable to civil proceedings, right? And also for people who may at a later point in time had some interface with tribunals such as appellate tribunals, NCLAT or APTEL, where I practice much more regularly, regulatory fields. They draw from the evidence field, but they are not bound by it. So it applies at all stages, and it's also applied to departmental proceedings sometimes. Okay. Now, finally, what I'd like to also bring forward is that in 2008, when the Information Technology Act was amended, there was a provision and presumption as to admissibility which was added to the Indian Evidence Act, where that entire business of having a affidavit by a party which is furnishing electronic evidence first commenced. However, for a number of years, these affidavits were not filed. And in fact, there are contrary Supreme Court judgments where first the Supreme Court holds that for admissibility, a affidavit specifying as to the nature of the electronic evidence, who has gathered it, from which machine they have gathered it, when they have gathered it, in the normal course of operations, etc., is not necessary. But later on, it is held to be necessary. And now there are further incremental changes being made through the addition of the new provisions. With this, I'd like you to understand is that there will be a period within which there will be a level of confusion, inconsistency of practices, which is natural to the very nature of how technology and electronic evidence is being gathered. And here, some degree of clarity is being provided by the superior courts. I'd like to specifically mention the Delhi High Court e-filing rules 2021 and Appendix 7, and this is available on the Delhi High Court's website. I would encourage all of you to look at Appendix 7. because it is not only useful for a lawyer like me, but it is also useful for judicial officers. How do they store, maintain, verify any kind of electronic evidence which is filed to them beyond the specimen forms which are provided under the BSA? And this is also relevant for you because these will be the very rules under which an appeal may be filed by a litigant to the orders or to the cases before you. And I do not think so there's a material contradiction or distinction between what is there in Appendix 7 and what is there in the BSA. Very briefly, if you look at Appendix 7, it is also accompanying a form which is called Form A and says memo to be attached to the electronic record. I'll read it out quickly. It says name of the court, case number, cause title of the case. Then there are fields which need to be filled in a pro forma. The party producing the electronic record and the name of the person tendering it, description, which means the device, brand name, serial number, then the operating system, software, number of files, duration of each file, etc., etc. And at the end, there's a date, place, it's signed by the party as well as the counsel. Now you may ask, why is all this paper being generated? Why do we need somebody to attest to each electronic record? And that is a good question to ask, especially to any person who practices civil disputes, because most civil disputes are essentially disputes to obtain interim orders, not to proceed towards trial. But these forms, these statements do become relevant once a witness enters the box and they are questioned as to the veracity of evidence. Because today, virtually any lawyer or any court is dealing with the epidemic of screenshots. Most of your cases will have screenshots. If it's a personal dispute, it's a family dispute, it's a tenancy dispute, it's a matrimonial dispute, everything is going to be a WhatsApp screenshot. Now, is it admissible? It may be admissible, but the person who's providing the screenshot may also need to provide you with the hash value. And that hash value can be calculated on the basis of exporting of that entire chat conversation now under provisions of the BSA to, let's say, Google Drive or an iCloud Drive backup, depending on if it's an Android phone or an iPhone, and then extracting the hash value. So one of the questions which was put to me was that what is the difference between what is a digital evidence and what is electronic evidence? Electronic evidence is a broader category, and one of the species within it is digital. Electronic can also mean biometric. Okay, and prior to digital, we had analog. What is digital? Digital means digits, which is fingers. And digital, all kinds of digital data is basically a sequence of zeros and ones. And if you would like to learn more about this and may not have an engineering background, which I think is very necessary today to even function in this world, there is a great, what is called as MOOC, Massive Online Open Course called CS50 for Lawyers. And it's available on the Harvard Law School's website. You can do it at your own pace, and you can learn more about how technology is used in legal practice and what basics of computer engineering you need to know. It's not as technical to completely prevent you from learning. It is aimed for comprehensibility by people who come from a social sciences background. Okay, now let me proceed ahead. Now, once you look at what is a iCloud backup, or somebody takes it out, or even on a pen drive or a CD, the next important thing to mention and to focus on is the hash value. The hash value is a unique fingerprint which ties to the status of a piece of electronic evidence not being tampered, because a mere change in capitalization, for instance, my name is Apar with A capitalized and P-A-R. But if all alphabets in that same electronic evidence which is filed in court, which is just my name, Apar in one text, is now all capitalized. A capital, P capital, A capital, R capital. It outputs a different hash value, which means the evidence has changed, right? Also, the hash value ensures that arguments are prevented at a later point in time in which the litigant says, my evidence has been tampered. And of course, it means greater reliability in evidentiary processes of criminal investigation when seizures are made. Here, the generation of the hash value is an automated and a simple function, but does need to be followed and will present challenges. You can do it for a website by clicking on the lock feature, which is there on any website, and looking at what is called as SHA. You can, and there are different kinds of hash values you can create, like a ND5, which can be done for any file. I would encourage all of you to look it up. There are YouTube videos which teach you how to do it in 2 to 3 minutes, but these are important things. There are some challenges I'd like to highlight before I end. The first is the multiplicity of documents, and this matters especially for filing offices, but also when evidence and the new form of charge sheets may be presented in court. Each piece of electronic evidence needs to have a hash value. And there are so many pieces of electronic evidence. A CCTV image from there, a different CCTV image from another recorder, a call which has been recorded by one party on one device, a computer or a desktop device which is done separately. So a tabular format will need to be created, which will accompany the certificate in Part A, if you turn to the very end of the books which are in front of you. Okay? The second primary challenge which I think people will face, especially lawyers, will be the role of the expert. So it states that, and this follows up from a conversation I was having on a lawyers WhatsApp group where lawyers reach out to each other and ask, iska format hai, uska format hai, ye file karna hai, wo file karna hai. They said with the BSA coming into force, should we file the templates of the affidavits which we were filing earlier, or do we need to even accompany them with Part B? Now, if you turn to the very end of what's in front of you, in the specimen format, you will see Part B. And Part B says to be filled by an expert. Who is this expert? There is some hint in it in one of the earlier sections. Under the IT Act, it says expert is an expert of